Welcome to Bankruptcy, Through the Looking Glass, with Barry Levine.
Hello, and welcome to Through the Looking Glass with Barry Levine. I'm your host, Katie Roberts, and today we're talking about divorce and debt division. Barry, thank you so much for being here.
It's always a pleasure. I noticed to my side, I sort of have a halo. I should tuck my head down there. Maybe he's God. Oh, no, it's okay.
Oh my, Barry, you are a trip as always. Okay, I know this is a very hairy topic. So with bankruptcy and divorce, how does filing for bankruptcy before or during a divorce impact the division of joint debts and assets?
A divorce sort of runs outside of the bankruptcy. The only time, and I leave this to the divorce practitioners, is when a couple settles in a state. They have the final decree. They want to couch things when they transfer assets in terms of alimony and child support. Because very often, especially now out in the Worcester part of the state, the trustees tend to ask, have you filed for divorce in the last 4 years, figuring they're going to find some property that, has been Yeah. And, I've often felt like saying, have you ever found anything? But that's just me.
Oh, that's interesting. Okay, so
it really, I think I was talking about the creditor's care. I mean, it really runs outside of the bankruptcy. I mean, it doesn't stay a proceeding. It doesn't have anything to do with the proceeding. In fact, the financial statement in Massachusetts anyway, that a couple has to fill out in a divorce is a hell of a lot more onerous than what you have to fill out in a Chapter 7. And the judges take it a hell of a lot, at least my feeling is it is a lot more significant in the scheme of things. Why, I don't know, but it is.
That is really interesting. So I'm curious, when there is a shared debt in a divorce, when one spouse files, what happens?
The non-filing spouse, I mean, right now, before this, I had somebody come in and his wife isn't filing, and you have to be very sure that she's not on any of the debt. If she is, then she will bear the consequence of the remaining liability. In situations like that, when the wife doesn't file, I do in Massachusetts again. And maybe I should just pretend I know about everything in every state. Well, in Delaware, it's this way, and Kansas, it's like nobody cares. But in Massachusetts, you're entitled to a free credit report. And over the number of years I've been doing this, on occasion in the non-filing spouse's credit report, they'll find that the bankruptcy has been listed. And the non-filing spouse has never filed. It's annoying. It can be dealt with through a dispute letter. Show me where I filed bankruptcy. And until they can do that, it needs to be removed. But that's the only thing I suggest, because otherwise most of the folks who come through my door are pretty careful when the one files or the other files. And, the other time it happens to sometimes be is, one files, the husband files to stop the foreclosure, and that turns out to be non-successful. And then the wife files to stop the foreclosure. It's a living. I can tell you this. I once represent, they always come to me when, if they had great times, by the time they come, I had a secretary, the only thing they still have is the nice cars, who said, why do all these debtors drive Cadillacs? They couldn't understand it. But this guy was a hoo-ha landscaper, arborist, whatever you want to call it. And I remember when I was in my sailing days, I was crazy enough. I once bought, I went out one day and I bought a 27-foot sailboat. I don't do things like that anymore. Please, it would be fun if you lived someplace where you can use it all year. But in Massachusetts, it doesn't exist. You have to pay, they all have money. But this guy, you should have seen this powerboat. It was like 62 feet. My sailboat was parked in a slip next to it. He was a macher, a big freaking deal. The local magazine, North Shore, had wrote an article about, don't ask. I would say his name because it's all a matter of public record. But so, by the time he came to me, he still had his house, didn't have the boat. The business was gone. It was a case of dueling Chapter 13s. First he filed, then she filed, then he filed again, then she filed. finally, the court had already allowed relief from the stay in anticipation of his filing. And he sent his wife and children to the movies, and the state police came with the moving trucks and escorted him out of the house in a very fancy town north of Boston.
That's gotta hurt.
But, the thing is, most of them, the divorce, I think she finally divorced him too. I couldn't understand why they were still together. He was living in a halfway house down the block here. Most divorce stuff has nothing to do with the bankruptcies. I mean, it's really a case of, was there $1 million that was, settled as a property settlement, within a certain period of time that a trustee could try to recover it. But mostly it's, whatever's happening up in the probate court, more power to them.
So I'm curious, when someone does file for bankruptcy during a divorce, do you ever have to work with that family attorney?
Just maybe to let them know of the bankruptcy filing, which they should, that it's been filed.
Oh, okay.
It really stands, less work I have to do, the better. It really stands outside of what I'm dealing with. The only thing I may say, and like I said, if I know it, they should know it, is that any, divorce settlement things should be couched as alimony and support as opposed to property settlement, because then, you're looking at something that could be, even if there's a house involved, the fact that it's in the divorce sort of takes it out of the hands of the bankruptcy. And most times it's like exempt anyway because of the homestead. So whatever happens to it, happens to it. But, the only time divorce, for instance, very often I own the house and you own the house and we go through a divorce and the judge says, I have to convey the house to you. And well, the thing is, the only thing that makes sense is for me to get off the mortgage. It also says I'm supposed to get off the mortgage, which is somewhat next to impossible because the bank has to agree to it. And it's very rare for a bank to allow, they have two debtors. They're going to let one go. That is like the case I have now is under his divorce. He was supposed to do that. He decided to do it 3 years later.
So this means that's an example that you just painted of someone not making themselves judgment proof during a
divorce is different. I mean,
okay.
That, now you're talking about hiding assets and crap like that. That's between husband and wife. That has nothing to do with, that's at a different level. Mostly everything needs to be disclosed. It's like the story of the guy who asked me if he had to list the house he owned in Maine. And I said, schmuck, now you do. As debtor's counsel, I mean, if I only know what the debtor tells me. I don't check every registry in the country. If they happen to own property in California, I fucking don't know. A client of mine actually, and this is many decades ago, forgot this was in the go-go 80s when the banks were failing and the property was one day worth, that's when my wife and I bought a condo, was worth $1 million and the next day was worth $500,000. We were not quite the same, but we were involved in that situation. And he forgot he was a developer because all these mill towns around Boston the properties were being developed. And he forgot about some properties that he owned. I mean, he forgot. And this creditor's attorney, I mean, you should have, back then to check what was at a registry, you had to go to the registry. It was a different world. And now I can, most registries I can be like like I'm a wizard. I can tell the clients while they're sitting here and access it. I can also check out what toilet paper they use. But then what was I going to drive to every registry of deeds in Massachusetts to check? And this was someplace in, do you know what dreck off and deck means? In the middle of no place. That's also Yiddish. You don't know any of this stuff. We have to get you some Yiddishkeit.
Okay, next episode, we'll do a Yiddish episode.
Well, no, then you'd have to, somebody who, when it comes to foreign languages, I just smile more.
That's what I was doing. You didn't catch on.
Yeah, my wife and I traveled Italy. She's very good with languages. I have no clue, but people think I'm Italian. And I would just smile as they babbled at me in Italian.
When I was in Budapest, I was asked for directions several times. And I was like, you don't want them for me.
The food in Budapest is very good.
I will never stop talking about the food in Budapest.
We had some very good pork in the Jewish corner, but that's a story for a different day.
I am curious about this one. Can bankruptcy eliminate or reduce the amount of debt one spouse is responsible for after a divorce?
Yes, it can. I mean, a discharge in bankruptcy is a discharge in bankruptcy. I don't necessarily know whether very often, though, the obligations of the divorce take precedence of, they can discharge the debt, but the wife may still have recourse to the ex under the divorce decree where he said he would pay those credits. So it's, it's something that has to be paid attention to. And over the years, I've actually, couples considering getting married, one or the other have filed bankruptcy in advance of getting married to discharge, to get rid of their debt.
I mean, that sounds like a pretty great avenue.
It's between two people, but who's somebody to tell somebody else they need to file bankruptcy? Otherwise, I'm not going to marry you. But it's not my business. Growing up in New York, they used to post notices that on such and such a date, I won't be no longer responsible for the debts of my wife. I still don't know what that meant, but it must have had some purpose in New York. But here it's like premarital planning, like pre-bankruptcy planning.
I mean, it's a big financial decision when you get married.
You don't want to be in a situation where right now, very often when people file a Chapter 13 and, very often, let's say it's the wife's debt. Don't get mad at me for being such a,
I get it.
But it's her debt, and the husband is the only one who works. And under Chapter 13, if they're over the median income, it's basically the husband having to pay his wife's debt. I don't think that should be, unless, of course, he benefited in some way. But if she's kibitzing all by herself, it's her own credit card debt. Why should he use a nickel of his money to pay any of her debt? But that's the way the bankruptcy code is written. The household is the thing.
Wow, that's really interesting. So let's say this specific couple, as an example, has considerable amount of debt, but then they're also they have a lot of assets. Are there any special considerations for this type of couple when filing?
It's really, the only consideration would be to look and see, if there are any assets that are at risk in context of the bankruptcy. It's possible, but, it's highly unlikely because, like I said, most assets are exempt. And then it's strictly something that the divorce judge, the probate court judge, is going to deal with.
Okay. What are some common misconceptions divorcing couples have when it comes to the shared debt as they file for bankruptcy?
Actually, if the couple is filing a bankruptcy and divorcing, that's probably the best way to go about it, because then you don't have the issue of the debt and who's going to deal with whose debts or the other debt. It's gone, and those are most of the situations that I'm involved with. I don't find, there are not a lot of active divorces, going on. And if it is, it's usually a situation where it really, from my perspective, doesn't matter. Somebody consulted with me. They were, they giving me a whole Gonsa McGill about what was going on in their divorce, and it really had nothing to do with her filing a bankruptcy. And ultimately, after wasting my assistant Kathy's an hour of her time, she decided she didn't want to file a bankruptcy. So, as my mother used to say, "Geg is ut de hay."
Geg is ut de hay?
Yep. Talk to your grandparents about it. They're probably my age.
Oh, okay, fine. I think that's it for our questions. I do have a request.
Sure.
Will you teach me and all of your viewers a new Yiddish word that is PG-13?
Oh, PG-13? Geg is ut de hay. Go in good health. I recently had, because, growing up, especially, I was telling people my father, who was the only Native American of the group of in-laws, spoke Yiddish better than my Holocaust survivor in-laws and my mother, who was Viennese, and she only spoke German,
Oh.
No, not really. I would prefer to learn Yiddish. But I really don't. I only know Yiddish from growing up in Brooklyn. I refer to everything, when you deal with, in law, we deal with a lot of dreck. And to me, you know what dreck is? Dreck is shit.
Oh, good to know. I always say I'm schwitzing.
No, schmutz is, my wife says I'm schmutzitic. I don't like to change my clothes. What can I do?
Whatever.
But the thing is, they took offense to the use of dreck. And to me, dreck is not, that's what it means, but that's not how it's used. To me, wasting my time and providing somebody's documents is putting together a lot of dreck to make you happy.
Yeah.
Right? You know what I'm saying?
Yeah.
It's not like real. I wouldn't say calling it shit. Yeah. Well, chazarai, that's another one. See, we'll teach you. That's pig.
I love it. Piece of cake. Thank you for joining us on Bankruptcy Through the Looking Glass with Barry Levine. You can connect with Barry at levineslaw.com. Be sure to follow, subscribe, comment, and review the show on your favorite platform. We love having you as a part of our community. And Barry, thank you so much for being here. It's always so much fun speaking with you.
Sei gesund, everyone. See you next time. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.